Good morning, this is your Kelso Report for Friday, April 27th, and I'm your host, Clark Kelso. Today we have cases dealing with absolute immunity, election law, criminal law, death penalty, and revenue and taxation. We begin with a Ninth Circuit case involving absolute immunity of government officials. The Nevada Board of Medical Examiners held an ex parte emergency proceeding at which they summarily suspended Dr. Buckwalter's authority to prescribe medication. Dr. Buckwalter filed an action against the individual members of the board under Section 1983 for damages and injunctive relief. Well, the Ninth Circuit held that the individual board members were absolutely immune from damage actions, challenging decisions reached by the board, and then, in addition, the doctrine of younger abstention applied to bar the federal courts from exercising equity jurisdiction over a matter that was still pending in a state administrative proceeding involving important state interests, where the plaintiff had the opportunity to litigate its claim. The Ninth Circuit affirmed the district court's dismissal of the doctor's claims. Next, election law. In Crowley v. State of Nevada, the plaintiff lost a local election for the Churchill County Justice of the Peace. He requested a recount, and after the recount again showed him the loser, he filed suit in federal court alleging a violation of the Help America Vote Act. The district court dismissed the plaintiff's action under the Act and under Section 1983, and the Ninth Circuit affirmed, holding that Section 301 of the Act was not intended to benefit voters or candidates in local elections with respect to recounts, and there was therefore no private cause of action under Section 1983. Section 301 speaks solely in terms of voting processes in, quote, an election for federal office, close quote. So by its own terms, it does not apply to an election to the Churchill County Justice of the Peace. Next, an interesting intersection of criminal law and administrative procedure. The two defendants in United States v. Backlund were living on National Forest System lands, and they argued that their full-time residency on such lands was justified by the fact that they were engaged in bona fide mining activities. The Forest Service held separate administrative hearings and determined that their residences were not reasonably incident to qualifying mining operations and ordered them to leave. When they refused, the Forest Service prosecuted and convicted them for violating 36 CFR Section 261.10, which prohibits a person from maintaining a residence on National Forest System lands unless authorized. Well, in United States v. Backlund, the Ninth Circuit held that the Forest Service does indeed have the power to regulate residential occupancy of bona fide mining claims within the national forests. That Section 261.10 is consistent with the mining laws and not unconstitutionally vague, and, most importantly, that in a criminal proceeding predicated on the Forest Service's administrative determination, a defendant may obtain judicial review of the agency action under the APA in the criminal proceeding, so long as the defendant complied with the procedural requirements for direct review, and the APA statute of limitation has not expired. Now, in these two cases, one of the defendants failed to exhaust his administrative remedies, so the Ninth Circuit affirmed his conviction without further judicial review of that determination. In the other case, the defendant had properly exhausted, and the district court had erroneously refused to review the service's determination, so the Ninth Circuit reversed that conviction and remanded for further proceedings. It's always wise to exhaust your administrative proceedings. The Supreme Court of California had two death penalty decisions yesterday. First, the defendant in People v. Livingston was convicted of the first-degree murders of two victims under the special circumstances of multiple murder and lying in wait. 3 counts of premeditated attempted murder, possession of a firearm by a felon. As to the murder and attempted murder counts, the jury found true firearm and criminal street gang enhancement allegations, and also found true the defendant personally inflicted great bodily injury. The jury returned a verdict of death, and the trial court sentenced the defendant to death It took a unanimous California Supreme Court 45 pages to affirm the sentence. Our second death penalty case is in People versus Miles, where the defendant was convicted of first-degree murder with a special circumstance of murder committed during the commission of a robbery. In a separate proceeding, the same defendant was found guilty of first-degree murder of a second victim with the special circumstance allegation that defendant had been convicted of more than one murder, and the defendant personally used a handgun in the murder. Jury returned a verdict of death, trial court sentenced him to death, and a unanimous Supreme Court rejected the usual appellate claims in a 58-page opinion and affirmed. Finally, revenue and taxation. A business operating in an enterprise zone can claim a tax credit in the amount of a percentage of the wages paid to a qualified employee. To claim the credit, the business must obtain a certificate from a government agency, that local or state, that provides that a qualified employee meets the statutory eligibility requirements. Well, the taxpayer in Decon Fiber Optics versus FTB did just that and claimed the credit. But when the Franchise Tax Board conducted an audit, an issue arose about whether some of the employees truly were qualified. The taxpayer produced the government certifications and argued that those certifications established it. But the FTB argued the certifications did not establish by themselves all of the statutory eligibility requirements, and the taxpayer had the burden of producing further evidence establishing all of the requirements were met. The Court of Appeal found in favor of the taxpayer, holding that the written certifications were at least prima facie evidence that all of those requirements were met, and the burden was shifted to the FTB to prove the opposite. Well, that was a nice holding for the taxpayer, but the California Supreme Court reversed unanimously, holding that when the FTB conducts an audit, it may require the taxpayer to establish that its workers are qualified employees within the meaning of the statute, and they may require the taxpayer to do more than just produce the written certifications. The court's holding was virtually compelled by the general principles that tax credits are construed strictly, the FTB's audit power is construed broadly, and most important when conducting an audit, the FTB is not bound by any determination made by any other governmental entity. Given these principles, and absent any legislative intention of the contrary expressed in the Enterprise Zone Act, the court held that the burden remained on the taxpayer to establish that its employees were properly treated as qualified employees. It's no wonder that the Franchise Tax Board is such a popular government entity. And that's it for today's Kelso Report. Have a great day in the law.